even a client, you know, just to go to court for going sake. So I believe that if those lawyers, being political party leaders, can decide to come to Channels TV to tell the world that they have majority, they won the election. Peter Obi could say that he won the election, but when it comes to law, you will need to present evidence. You have to substantiate your claim. You know, what obtains in the comfort of courtroom is not what happens outside. So they have to establish that. I heard the argument they made on the issue of a federal capital territory. We have written an opinion on that, and I believe that today can share that opinion with members of this team. What the law says is you must call for you to be declared as president. Number one, you must have majority of lawful votes. That is to say, if you have 10 million votes, the second person to you may have 9,999,000. The moment you have 10 million votes, you have won, provided you can satisfy the second condition. You must have 1/4 of the total votes in at least 2/3 of the state or the federation, 2/3 and the federal capital territory. Now, and means 2/3 of 37 instead of 2/3 of 36. We have 36 states. Section 299 of the Constitution regards federal capital territory as a state. So it is 2/3 of 37 or 2/3 of 36. And 2/3 of 37 by Awolowo and Shagari is 24. Because Awolowo and Shagari does not recognize, the Supreme Court does not recognize fraction. That a state cannot be fractionalized. And that you have to take the figure before the fraction. And you know the figure, you know, 2/3 of 37 will be 24 points, so. You know, so you won't reckon with that point. You have to take 24 to use to calculate. That's what happened in Awolowo and Shagari. So that is the opinion we have rendered. You can share with the group. So I do not see how, and then come to think of it, what sense does it even make? The argument that some senior advocate, I was ashamed when I heard some senior advocate say, oh, the person must have 1/4 in FCT. Assuming the winner won election in 35 states and lost in FCT, does that mean they will now not declare him because of FCT alone? Is there any magic about FCT over Nigeria? It doesn't make any sense. I don't even know how a lawyer, what his name, could advance that argument. But that's the law, you know, when it comes to that. Tinubu won based on that as of today. But if Obi and Atiku, who are both claiming that they have won, can establish by credible evidence that they score higher figure than they were allotted, it will be very good for our electoral jurisprudence. Thank you.
Wow, thank you so much for that. And I want to thank our provost of the training institute. She's actually posted it on quite a few forums, because these are things that these are the conversations people are having all over the country. And there are loads of arguments between brothers and sisters and mothers and fathers and all over the place based on the conduct of these of the last elections. So before we move on to, please, can I ask you mute yourself? Please, everybody, as you come in, mute yourselves, please. So can I, the next, let me ask, does anybody have any questions at this
Yes,
point?
I do, Covenant. Can I ask the legal luminary?
Who is that?
Okay. This is GAHRD Jimo.
Oh, okay. Please go ahead and ask your question.
Yes, Barrister Tope. Happy New Year, sir.
Same to you.
Very well, very well. Right. So the question is, let's go back to the minds of the drafters of the 1999 Constitution. So let's try and put ourselves in their minds. What was the whole idea that
And what has motivated you to apply for this role?
1/3 percentage vote was required of the FCT for you to achieve before you can be declared a winner. So if you've gotten 1/3 of 2/3 states within the federation, why was FCT added as and the FCT?
Are you true?
Be honest. Yes, sir. Yes, it's just a brief answer. Thank you, sir.
Okay, can I respond? Okay, now there is nothing like there is nothing in the Constitution, Section 134(2) of the 1999 Constitution. There is nothing there saying that you must have 1/4 of the votes in FCT before you win election. It's not stated there. There's no mind. There's nothing. The law is when the provision of a particular law is clear, you give that law its ordinary grammatical meaning. You don't go to any mind because nobody's law. You interpret law that you see. Now let me read what the law says. It said the candidate must have not less than 1/4 of the vote cast at the election in each of at least 2/3 of the states and the Federal Capital Territory. The reason why the word and the Federal Capital Territory is put there is that so that it will be put beyond doubt that when you are counting the states that you want to use to judge the winner, you must count Federal Capital Territory in case the winner wins Federal Capital Territory. Let me break it further down. Let's say the person wins 23 states and Federal Capital Territory. That's 24. And somebody now says, oh, Federal Capital Territory is not part of it. Therefore, that person cannot be declared as winner. The Constitution is putting it beyond every reasonable doubt that when you are determining the number, you must count Federal Capital Territory as part of it. Not that it should be given a special status and then it should, not that the contestant or the candidate must get 1/4 in Federal Capital Territory. That's the law. There's no ambiguity in that law.
Okay, a follow-up question, sir, if I may.
Yeah.
And it's very simple. Based on the provision of the Constitution, is Peter Obi a candidate of the Labour Party?
I don't know what you
mean. I yield back, sir. I didn't. Well, obviously, the Constitution has brought forward that apparently you have to be a member of the political party for more than 3 months before you can stand as a candidate or stand as an aspirant within that political party. The question is, did Peter Obi fulfill that provision of that Constitution? Was he a member of the Labour Party for more than 3 months before he became the flag bearer of Labour Party?
I don't know where that is in the Constitution. If you can point me to that provision, then I'll respond. Okay. You know, people say all sorts of things online. People say all sorts of things online.
Okay, sir.
And then what the law says, if you read the provision of Electoral Act, section 84, the law already says that any qualification or disqualification requirement that is not stated in the Constitution cannot be a ground to disqualify a candidate. So if any law says you must be there for 3 months and it's not part of the requirement of the Constitution, that law is null and void. So you see a lot of things on social, although that's one of the reasons for this conversation. I don't know where they got that 3 month window. I don't know where they got it, But I've not. If you can point to me the law that they're talking about, then I'll be able to address it.
Yeah, I'm literally searching for it. So I'll get back to you. Please carry on.
Okay.
Okay, I think where it's from, there are quite a few cases in court. I think the one for the presidential one has been withdrawn, I think. But of course, we know that in the case of Lagos State, for example, there's still a case, and it's also related to this case, that per the Electoral Act, there's a requirement that the party list must be with INEC a minimum. I believe I might be wrong on this, but I think I'm right here. A minimum of 30 days before the party's primaries, and that every contestant must actually be have their name on those registers. In the case of Labour Party, there is this allegation. There's this thing that both the presidential candidates and the candidates in Lagos, for example, those two have been the ones in the news mainly, so there's been a lot said about them, that they actually fall foul of those requirements. So
unfortunately, if that, I know what you are talking about. If that is what Mr. Jimon referred to, and that has not been challenged before now, I can bet you it will be too late to challenge it. You have only 14 days. It will amount to pre-election matter. And when you have a grouse against the return of a candidate as a candidate of a political party, you need to raise your issue at the Federal High Court within 14 days of the occurrence of that event. So within 14 days of nomination of Peter Obi, somebody who, and then it's not everybody that is allowed to go to court for it. You must be a candidate in that election. So the question is, who contested with him in Labour Party to be able to challenge the illegality? So that one will be, I can bet you, they raise it, even if APC raises it, it's going to die a natural death. You know, because there are a lot of legal hurdles around it. And so that's what I can say about that, except somebody had alleged that he was a candidate before they came, before Peter Obi and Dati came, and that he was also, he obtained the presidential form for Labour Party, and so that will qualify him to be able to go to the Federal High Court to challenge the nomination of Peter Obi and co, and then and Dati. So there will be a lot of legal hurdle to cross for them to be able to establish that under the new Electoral Act.
Okay, thank you so much, Barrister. Because of our time, and I know, does anybody else have any quick question on that before we move on? I know Richard Jimon might be able to ask other questions later. Anybody? Is there anybody who wants to? Thanks for joining us. If anybody has any question, anyway, as we go along, you can ask your question. So, Barrister, you see that we're being very logical and systematic. You've actually already answered about the conduct of the election and the transmittance of the results via the INEC portal and the declaration of the results. Now, like you and I, and like everybody on this call tonight, we witnessed the compilation, the national compilation by the National Returning Officer, who is also the chairman of INEC, Professor Mahmoud Yakubu. And we witnessed the walkout from Dino Melai and quite a few other people. And of course, some of the other parties that were suspected to have walked out originally said, well, they dissociated themselves, they came back. Now, I know it's a foolish question to ask. I know the answer, and I know quite a lot of people know the answer. But when you go on social media, you see again and again loads of places where people have written that so long as your polling agent has not signed the results, the polling results for a polling unit, it's not valid. That all you need to do as a polling agent of a party is just don't sign it. It is not. And like Dino and Co worked out, that it actually calls into question the legality of the process. I know someone will be laughing, but it is very. There are quite a lot of young people out there who say quite a lot of these things, and it's just we want it to be on record so that come from someone who is learned in law. So, what do you say to that?
Well, the simple answer to that is that the refusal of a polling agent to sign from EC8A, either A, B, C, D, or E, is not a grant to notify the result of the election.
Thank you so much. Thank you. And the walking out of the collation center by the agents as well, that was in the same category.
No, they have their right to walk out. They are allowed by law. They have right to freedom of movement, so they can walk in and out of the collation center. It does not affect the result of the election at all.
Okay. Thank you so much, Barrister. So we've established quite a few things already. And then, of course, I'm going to take you back to that two-thirds of states. Now, I know you've answered to a large extent, but I'm going to bring another angle here. Because for me, the question, does the federal government, does the federal capital territory, and also trying to answer this question from, let me go inside the PLIDE Richard Jimon's mind and say, you know what? Could the framers of that constitution, of that act, of that act in particular, and of course that section of the constitution, have envisaged the situation whereby the federal capital is so important? It's a national microcosm. It's a representation of what the country is itself. It's a melting pot, just like. And of course, that argument can be extended to Lagos to some extent as well. But could they have intended that, for purpose of national unity and all those things, and for leaders to actually take that seriously in terms of who live there, in terms of their ethnic backgrounds and everything, mishmash? Could they have intended it that way and said, you know what, you would have to actually have FCT as well? And I said this because your senior colleagues, like I mentioned at the beginning of the program, Barrister Ozekome, it was particularly for someone like, it was tough to watch, to be honest. But of course, there were others. There have been other lawyers. The gentle Barrister, is it Inibe or Ibine Efyong? The one from the South who was sent to jail by the Chief Judge recently. And quite a few of them have come out. And of course, the barrister that went to court in the native, in that Jujuman attire, with the chalk around his eye. These are lawyers of note, quote and unquote, who have come out to say, you know what, based on law, the president-elect as of today has not met the requirement of law to be so declared the president-elect. What do you say to that?
Like I said, it's unfortunate that the only person of note among those people that you mentioned is Sekome SAN. I'm surprised that he could lend himself to that. The Effiong guy is a young lawyer, and I don't think he had a lot of what we call experience to be able to understand how to handle issues like this. The fact that you are popular does not mean you actually know the law. But leaving that aside, there's something we call purposive interpretation approach of the Constitution. This was employed in the case of AG Lagos State and AG Federation, Part 904, Nigerian Law Report. That purposive interpretation approach is what my brother was talking about when he said he was looking into the mind of the drafter of the law. Now, is an Herculean task to be able to establish that, to be able to ask the court to undertake the purposive interpretation of the Constitution. Now, for you to be able to do that, you need to get, they will need to exhibit the conversation that led to the draft of the Constitution. If the conversation brings out all these points that you are talking about, they can now use that one to urge the court to say that, yeah, this thing is not very clear, but look at the people, look at the conversation that happened. Now, that was what Lagos State used. Oshibajo was the Attorney General of Lagos State when Lagos State took the federal government to court in respect of physical planning laws. You know, for the court to determine that federal government has nothing to do with physical planning is in the exclusive preserve of the government of Lagos State. And now it was a huge debate, and to be able to establish it, despite the fact that there are laws, there are provisions of the Constitution that support the state, they went ahead and get the conversation of the committee that was set up to discuss that provision of the Constitution. So, and then it was clearly stated that these things are imputed in the Constitution for this particular purpose. You know, so purposive interpretation of, you don't just say it and then expect everybody to clap for you and say, even if a candidate has maybe 10 million and others have 500,000 votes, and those that have 500,000 votes have it in FCT, and the one that has 10 million does not have it in FCT, therefore you will nullify the election. For you to be able to have the court, to persuade the court to make that the entire nation waste money for that, you need to bring that conversation and exhibit it to say this was also in the mind of the drafter at the time of drafting this constitution. By the time Court of Appeal decided this matter, because I'm very confident, you know, it was like the way I was confident about the Obi movement when we were talking the last time. I'm also confident that this is going nowhere. I'm not saying they may not win the petition, but I'm saying if they are going to win, it's not going to be on this flimsy SCT thing. It will not happen. It will not happen. And I know no such conversation took place. Let us even put up our thinking cap. Assuming you call it a melting point, do politicians stay in Abuja during election? Don't people go back to their different states to go and contest election? People go back to their different states. All the people that most of the politicians in Abuja are there as a result of having been elected into the place. And this election we are talking about include the National Assembly member who populate Abuja. So, and are you saying also that all states are evenly represented in Abuja, so that Abuja can then be in the melting point? Where is the data and statistics to prove it? That Ekiti has the same number of people in Abuja like Niger State, as Nasarawa State that is very close to the place, as Kogi State that is close to the place. So assuming Abuja is majorly populated by Niger people, and Niger people are the one who have their indigenous as a candidate, they will just frustrate the candidate. So there's no basis, there's no statistical basis, you know, to justify the argument being made by people. You know, there's no statistic to justify it. If, for example, in the making of Abuja, maybe there's a regulation that all states must be evenly represented, you can say, okay, maybe this is part of the argument. But if you find that, you see that some states can have as many as 30% of the population in Abuja, while some may not have up to 1%. Do you understand? So that argument does not fly in any way at all. Thank you.
Thank you so much. I must believe.
Sorry, Colonel, can I make a comment?
No, just hold on, please. I'll call so that it's orderly, so that I can add anybody. Just don't worry, I'll call you next. Please, if you want anybody that wants to ask a question or make a comment, just use the hand tool, and I'll call you definitely. I want to thank Barrister. The way you broke that down, it's like stupid 101. You know, it's like anybody can actually, and this is very important. You will be shocked. I repeat it. You would be shocked at the argument online by many people. In fact, they're not even talking about results anymore. Maybe by just saying, you know what, based on this FCT thing, they know that. In fact, yesterday, I remember reading quite a few things online, and a lot of people were already saying, that well, they're preparing for a runoff election because the elections will be, well, there will be a runoff because Tinubu, the president-elect, did not meet that requirement. Thank you for breaking that down. So I'll take PLIDE Richard's Jimo first now. Whoever wants to also ask a question, please let me know. Just so that's what we'll do tonight. We'll take questions and comments before we move on to the next questions. So, Richard Jimo, please unmute and fire.
Mine, it's not more of a question, but rather of a contribution. And I thank the barrister for really putting it as it is. I want to believe in the minds of the drafters of the Constitution, the fundamental thing which they would wanted to avoid would have been ambiguity. Okay, so, and obviously, as this has played up, it takes us down to that maxim of laws being made for men and not man for law. So I want to believe that at the inception of the next administration, one of the very first things which they will look into will be the review of that section of that act, because it, like you rightly said, it is actually bringing well-respected legal minds and exposing their flaws. Yeah, to be quite honest, like as the barrister said, the law can be as simple as a man in my village will be able to understand at times. And in that type of instance, I see it now. So, like the question which you asked, if a candidate wins 35 states in Nigeria, but does not win the FCT, are you saying the law will be an ass to that point and saying we will not declare the man who's won 35 out of the 36 states in Nigeria simply because he did not win FCT? Do you understand? So I want to believe that people are just, like you rightly said, people are latching on straws here. People are latching on pure straws here. With the inception of the next administration, I know that ambiguity in that constitution, it definitely will be reviewed within the first 6 months of the next administration. I want to believe that. I yield the floor back to you.
Now, once the Supreme Court, I don't want to believe that the lawyers to Obi will put it in their petition, or if they are experimental enough to put it in their petition, Supreme Court will, give a verdict, a clear verdict on it, and once Supreme Court interpret that provision of the Constitution, that settles it. We don't even need to amend the law again. That will settle it forever.
Thank you so much, Barrister. Does anybody else have anything to say on this comment question before we move on? Anybody?
I mean, Miss Andy Paul.
Yes, sir.
Please,
good evening. Good evening, everyone. Am I clear? Can you hear me? Okay. I'm not a lawyer, but this particular matter is interesting. And I think Section 2 and 3 and Section 3.1 or 3.2 of Nigerian Constitution describe the federating unit of the country. And basically, my understanding is that the federating unit is described as 36 states and FCT. So if another law now refer to 2/3 of 36 states and FCT, isn't that very clear that the law is talking of 2/3 of the federating unit of Nigeria? But like I said, I'm not a lawyer, and sincerely, not everything that looks simple is simple. So we'll leave that to the lawyers to deliberate on, but from my perspective, I just feel that since the Constitution described the federating unit, and the electoral law is talking about 2/3 of the federating unit. I think that should make it as simple as it should be. Thank you.
Thank you so much, Barry. Like I was almost going to say Barrister Adebayo Onajobi. He's a very senior banker, so Barrister, over to you. Let's get that back to you.
Yes, well, to the extent that your point is that the 2/3 contemplated by the Constitution means 2/3 of 37, because in terms of state, the federated states in Nigeria are 37. By Section 299, the Constitution regards FCT as a state for the purpose of the Constitution. So federated states are 37. So when 2/3 is to be reckoned, it will be 2/3 of 37, not 2/3 of 36, which I said in line with Awolowo Ashagari means 24 states. So that's the point that has been made. So you are right. If that is the point you are trying to make, you are right, sir.
Okay, thank you so much. PLIDE Onajobi, does that clear your question?
Yes, I think we're saying the same thing.
Oh, thank you so much. Thank you so much. Is there anybody else? I don't want to leave anyone out. Okay, so we move on to the next. We've talked about the qualifications and everything. Now let's go, and I know this is the controversial part. Let's go into the conduct of the elections itself. Bad instances where polling unit presiding agents were actually very supportive of certain candidates. We've had instances as well where, I mean, there was a video in circulation where someone actually, said, people of a particular ethnic tribe, ethnic stock, would not be allowed to vote in that election. Because we're trying to look at what constitutes electoral crimes, and do they vitiate the result of the elections as announced, and also how do you view them within the context? Because we're still talking about substantial compliance, which we know is going to be the key thing in law, in the courts. And of course, there is every belief, and of course, the 900,000 votes that, for example, our obedient brothers said they actually, our brothers and sisters actually said their party actually had in Lagos and quite a lot of things. And of course, we had videos as well. Incidentally, this time around, we actually have not had too many videos from or evidences from the north. They've been mainly from the southwest and the southeast. And when we talk about the southwest, really it's just been Lagos alone, and of course the states of the southeast as well. Where going to the southeast, there were loads and loads of evidence of people being physically prevented from actually voting for opposition parties, DP, APC, NNPP, and co. And of course, that example I gave of Lagos as well, where this person, quote and unquote, let's not call him names, actually said he was going to physically prevent people of a particular ethnic stock from voting. And of course, we saw the police, rather than arresting that person, actually trying to usher that person into a pleading with that person, really, to move the person away. And from your own, from the reports you've gathered, I know this matter, like you say, is sub judice, it's in court, and I know you probably don't want to comment too much. But from the things you've gathered and looking at different legal authorities you might be thinking of, would you say that by and large, the conduct of the February 25 elections were in line with the requirements of law? And of course, I will now take it further and look at the cases that were instituted in courts, especially by the Labour Party, which said, Peter Obi and Labour Party, when they said that they wanted to physically inspect the Beavers machines. And of course, the courts, quote and unquote, was reported to have given them the leeway to go and do that, authorized them to do that. And of course, CBN, INEC appealed. And then wanted it to be varied, saying that they needed it for the conduct of the March 11 elections, which were supposed to be held yesterday and which was postponed, obviously, because of the court case. And now, going back to courts, the court said to INEC that, well, we never gave some of these injunctions that you actually thought we gave. We never said you had no right to control these machines or do all, and then, of course, the other parties are saying, reconfiguring these machines would actually evidence. And of course, INEC went back to say, you know what, look, we've got everything backed up in the server. Look, please, could you unbundle all these things, the court case, the Beavers thing, everything? Could you unbundle them and please help us make sense of them as they affect the legality of the validity of the election, and what can we even expect the upcoming court cases, because there's no one court case, and the court cases have not even been, they've not all been joined together now. They're still separate cases. So please help us to make sense of all these, because there are things people are talking about every day.
Okay, thank you. So first and foremost, let me say that establishing non-compliance with the Electoral Act by bringing out the case of Tope, voters obstruction, suppression, and all sort of criminalities that happen in different polling units is going to be a very Herculean task for both Atiku and Obasanjo. And Peter Obi, given the state of the law with respect to electoral jurisprudence. You can appear on TV and allege widespread irregularity. When you get to court, you must do what I call particularization. You must indicate exactly which polling unit the alleged infraction occurred. And you need to call witnesses from each of those polling units. Meanwhile, you have only 6 months to prove your case. In fact, they have 6 months from the filing of the petition to the determination of the petition. So the time Labour Party or Atiku has to even present their witnesses is no more than a month, 30 days maximum that they have. Now we have 176,000 polling units in Nigeria. And for you to show that there were irregularities of substantial proportion to nullify election, minimum you establish it in 30,000 polling units, which means that you have to call 30,000 polling agents to come and testify. And those polling agents, we have to be taken through the fire of cross-examination. So cross-examination will establish that the testimony can either be trusted or not trusted. So for anybody that wants to stand for election, your best bet is to ensure that you work on getting agile, educated agents in all the polling units and ensure that you secure, your results without being tampered with. In majority of the polling unit, let's say we are only challenging, election in few of the polling unit now. It won't be very bad. That's what they did in Osun State. For you to win election petition, you must isolate few places that you want the result to be nullified, so that by the time they recalculate, you can win the election. A situation where your allegation is widespread will be almost impossible to establish, given the state of our law. Now, that's number one. Number two, the obstruction of electorates, all the criminalities perpetrated by thugs in Lagos and some other areas, those are criminal allegations. It is expected under the law that those that were prevented from going to vote should have incidented that act with the police and obtain a copy of the petition written to the police or the report of the police on that. to say, yes, we have investigated this matter, and true, we arrested ABC, and those people claim that they were actually sent by APC. So, and then you have to bring that to court to come out. And in a criminal matter, you must prove your allegation beyond reasonable doubt. Reasonable doubt does not mean all out of doubt. But the standard of proof expected of you is higher than when you make a civil allegation of commission of a civil wrong. Do you understand the point I'm making now? So,
yes, balance of probability.
Is that?
Oh no, sorry, I just said as different from a balance of probability on a civil matter.
Yeah,
sorry,
yeah, which is the requirement in proving civil wrong. Now, so there's going to be a Herculean task for them there, for them to be able to win this petition. I believe that they will have to narrow down to only few polling units or ward or local government, the one that they can manage within the time allotted to them by the law. If they want to prove widespread illegalities without any concrete evidence, it will be difficult because time is limited. It's limited. So I don't know what they have. I'm unable to comment on whether or not they have a strong case because I don't have access to the evidence. And then the beavers machine issue that was raised. I believe most of us here are familiar with how computer issues are handled. And I believe we know that definitely the claim of INEC that the data from the presidential election is backup, I don't see how that can be faulted, except you can then show that INEC, this is what you signed at our polling unit. This is what is now recorded in the report you are giving by beavers after you have tampered with it. If you make allegation that the result of the data in beavers has been tampered with, you must establish that allegation. You must prove it. A court of law will not agree with you that because INEC has taken the beavers for the president governorship and House of Assembly election, therefore they must have tampered with it. Speculation is not part of our law. Law is not speculation. We deal with reference in law. So they must go beyond mere suspicion that, it must have been tampered with, to come in with concrete evidence of actual tampering with the beavers report by INEC. And I believe that what they have, what PDP and then LP have will be, I don't know what they have, it will be the evidence they have that can be used to establish that. But did INEC have a right to approach the court to seek an order, varying the order, allowing Labour Party and PDP to inspect beavers? The answer is yes, they do. They do. And they can approach the court. They have right to approach the court under the Electoral Act. And what they have said is not something that cannot be verified. True, election was supposed to hold yesterday, but because of the interference, I think none of them planned for all this. Both INEC and the party did not plan for what has happened. But it is because of that thing now that the election has been postponed to next Saturday. So it's a fact that could be verified. The court is bound to take judicial notice of that fact, and the court did actually take judicial notice of it. So, submission, simple point. Number one, they have to call evidence to prove any allegation made. Number two, they also have to go beyond mere suspicion of tampering with the beavers machine. They must go beyond mere suspicion to actually bring in concrete evidence to show that the beaver machine were tampered with by the time those machines are given back to them after the election. And maybe by now they should have applied for the data already collected. I don't expect them to wait for the beaver machine before getting the data, because if they are really serious, you know, either before or after, they could have tampered with it. They wanted to tamper with it even before they apply for the beaver's machine, you know. So they should by now have applied to get this beaver's report, like our people did in Osun, so that they can compare what is in the beavers with what is in the Form EC8 series. Thank you.
Thank you so much, Barrister. It's this is really, really rewarding, and I know that we're not even going to have enough time to finish this, so I'm already thinking I probably have to bring you back, even though next week we're supposed to have someone else, but we'll probably might have to bring you back because there are legal issues, and we know there will be additional legal issues by next weekend as well. So does anybody have any question or comments or contribution to that before we move on to the next thing? Anybody? Richard Jimo again. Is it a previous one for the current? Okay. I mean, that's fine. I mean,
yes, sir.
Whoever raise your hand all the time, that's fine. So go on.
Thank you very much. Yeah, yes, I like the question which you had the barrister, and honestly, the barrister said it all. You know, I didn't know that Professor Patrice Lumumba of Kenya was actually a legal icon. There is a video which aptly answered this question. This question of pockets of irregularities or allegations of irregularities in a presidential election. Honestly, I'm going to look for the video before it closes and share with you, Convener. And maybe the way the prof summed it up there, it was absolutely beautiful. That for God's sake, God cannot be dealing with headaches or toothache when there are major issues plaguing the world. Do you understand? So in expecting that, in one polling unit, there is an irregularity there. That's what the barrister said. You must come and show that if you want to disqualify a presidential election, at least 30,000. 30,000. Now, good luck to whoever. How Patrice Lumumba ended summed it up in that clip was that there is no presidential election in the world, in the whole world, which had been thrown out in an election tribunal. He said, go and check anywhere in the whole world that a candidate wins a presidential election, and then you say he went, you opposition or other candidates will go to court and have his election thrown out. He said it has never happened in the history of the world. It will never happen. So anyway, are you back?
Tunde, you are muted. You are muted.
Yeah, Convener, you're muted.
So thank you. And I've been talking on and on. You know, we do this all the time. Thank you so much. I started by saying very big thank you to you again, Barrister, for helping us answer that. It was a mishmash. It was a mishmash of questions, and you actually delivered very brilliantly. I want to thank you for clarifying it. And it's not because you're here, but I say it again. The way you break it down, it's just stupid 101, and for me, I love it so well. Now let's go to this, and I know you probably think I'm pushing you into areas you probably don't want to go today, because of course after this we'll go into the CBN issue. Our obedient, our younger ones, the obedient ones, I've gone on and on saying that there are loads and loads of them who actually believe almost 100% that they won this election and that and many of them actually say they use, you would have seen that, you would have come across that phrase a few times, the authentic president-elect will be sworn. You know, they go on, and I've tried to interrogate their minds a few. And one of the things that I found out a few times has been that a lot of times, some of them, they would they'll say, you know, they just know the courts will do justice. So I'm going to start by asking you the first question I'm going to ask you. What is there anything in law that you can think of that can actually change the result as it's been announced, or change the person of the president-elect? Is there anything in law that anything you've seen from the conduct or from our jurisprudence that you can actually latch onto and say, you know what, based on these or these and these and these, or this or this, I know that there's a probability that the courts will overturn the result of the election. That's number one. Number two, one of the things I found very fundamentally worrying have been some of the prophecies as well. Now, for me, I think maybe it was our Secgen, I don't know whether it was the Secgen or someone else who I was having a conversation with, and I said, to me, it did appear like a Nollywood script. I think someone sent it to me and said one prophet, Faye Daniels. And for me, it was such a script, a Nollywood script, where he said, you know what, someone will win, and then someone will protest, someone will contest, someone will go to court. There will be so much protests in the land. There will be chaos in the land on the day of the swearing. The military will come and pick up someone from the Eagle Square, the venue of the swearing, and then the person will be taken to jail. Someone will be sworn in as an interim president, the head of an interim government, a la Shonekon style. For me, what is the defining line for treason? Incitement to public disorder, treason, because such a prophecy is so far-fetched, and when you interact with a lot of the obedient people online, in person, many of them actually hold on to that. And in fact, I've interacted with elderly people as well who do not even believe in the obedient movement, who are holding on to that as well. Somebody say, oh, this prophet has said, so there will be insurrection on the streets, and the military will arrest the president-elect as we know him today, and that, all these things will happen. For me, it is so much, because if people are holding on to that, and even some who would probably have accepted the result of that election, they said, there was this man, some of them said, there have been people who said, for me, I won't have a problem with the result of the election. But this man has said this prophecy, and we know it will come to pass. And also, so for me, don't forget, it's like, I've asked the first question. Now, this is another one, which is like multiple questions in one. What is the defining line? Where do you step off? And of course, we saw Pastor Enenche as well with his sermon in Abuja and everything. Where do you step from this freedom of speech onto treason, onto treasonable felony, onto incitement of public disorder? Because the constitution of the country says the only way governments can be changed is through the ballot box. Anything other than that is against the law of the land. And so when you have all these people saying these things, and for me, I've asked that question, are they committing any offense, or are they free to say that you and I, because so that if it is you and I tomorrow, and some of our younger members and older members, in fact, are we free to say such things without being invited by the State Security Service for incitement, for trying to cause public disorder, or for treasonable felony, or for outright treason against the state, calling for insurrection against the state, and also so? Where do you draw the line on all these things?
Okay, thank you. So let me just so as not to waste our time, let me give you like a direct answer to the two questions. The first one is whether there is any ground, that either of Atiku Abubakar and Peter Obi can rely upon to get any of them declared as the president and commander-in-chief of armed forces or the Federal Republic of Nigeria. Unfortunately, I'm not in their legal team, and I do not have access to what they have. But if what they have is the issue of FCT, I can tell you for free that is going nowhere. If what they want to rely on are the pocket of violence and thuggery in few polling units in the nation, I can tell you to not be regarded as substantial. If what they have is the a failure of INEC to transmit results real time, I can tell you almost for free that is not substantial enough to nullify the result of the election. But if they have collected the results all over the nation, and the results as collected by them and says that either of them won the election, and that result tally with the result with INEC, then any of them that can show that and meet the requirement of the Constitution will be declared. So what do they need? I expect by now, if they have that, for example, let's say they have Form EC8A that shows that they actually had, that Obi had 900,000 in Lagos has been bandied around. Then what they will do is they will simply go to INEC and apply for the Form EC8A, the one in INEC, and bring it and take it to court and say, we have done our tabulation, this is the result. And the result is derived from what we collected from you as INEC. It will be a tall order, but never say ever. That's on that one. So like I said, on all those other grounds, it can work. But if they can show by mathematical calculation that they won the election, judging about deriving their figures from documents from EC8 series obtained from INEC, then don't be surprised that either of them will be declared if they can show that. That one is on one side. On the issue of the prophecies, I actually saw the prophecy of that Pastor Sheyi. Well, a man rises and falls to his master. I don't know who he serves. But it looked like, to me, that didn't look like when it looked like in the olden days when our abbalists in town would be saying what Tope is saying, and they'll be narrating it. It was funny when I read it. But when I saw it, and I believed that this guy is just, for me, it's just joking around, So whoever believes that can believe anything. Number one, where I know that thing will not, that prophecy is just a wishful thinking, is when he mentioned that Obi will win at the tribunal. I laughed. I laughed. Because I don't know how he's going to set that precedent by being the first person to win the presidential, election tribunal. I'm sorry, election petition. So I laughed. Then when he said that Oshibajo will be brought in and he will become VP, these people are just trying to validate things that they've said in the past. And so for me, he has a right to freedom of speech. Does that amount to treason? My answer is no. It doesn't amount to treason because there is no overt act. A treason cannot be established without an overt act. If you want to say, oh, this person has intention to topple the government that is democratically elected, then you have to go beyond a speech. Anybody can claim he was drunk that day and he was just saying anything and he did not know that people would take him serious. Now you would have to go beyond that and say maybe you can, if you can show that he met some military officers a night before and that you have the proceedings of the meeting and they now sent him to go and pronounce that in order to be able to prepare the heart of people for insurrection. He can be arrested and charged for treason if you can establish that. But in the absence of that, just coming out and talking about what he wished should happen in the nation, a man has a right to go to heaven the way he wants. Thank you.
Thank you so much, Barrister. Thank you. I really love the way you come forward with all these. Now, there was a side you didn't touch on. Does that in any way amount to public incitement to disorder? You know, which I know is, would that in any way?
Public incitement to disorder, there's nothing in that word that for me, I don't see any. Even if it were to be, if you call it public incitement, the question will be under what, well, it can be, if he's going to be charged for that, if he's going to be arrested for that, maybe that thing, if it now leads to widespread demonstration and everybody is referring to him, then it can be called to question. But it won't be just that speech alone. There will be other things that will happen that will accompany the speech. You know, for the call you know, we are not in a military rule. It's a democracy, and so you cannot just pick up a person and say you are inciting public. He will tell you that is what God told him. Can you deny it? You cannot, because in 1993, you remember, Pastor Bakari said SDP will fail, NRC will lose, be cut off, the military will fail, verdict 93, God reign, and it happened. People said two parties are contesting, you say both of them will fail, and that the military will fall, that our God reign. What are you saying? Is that you say SDP will win or NRC? Why are you saying both of them will fail? And he said that, and it happened. So are you saying people should not serve their God? And he was not talking to Nigeria. He was talking to his people. He would tell the court that I did not instruct anybody to put this on social media. I was merely talking to my flock.
Thank you so much, Barrister. I'll just at this juncture give another. Does anybody have any question? Oh, Senator Messi is the only one with any question or comment at this juncture. Okay, can you ask that, because we're not going back to that topic until maybe next week if we can get Barrister back. Immediately after this, we're going to the CBN and the new Naira policy. So, Senator, please fire on with your question.
All right, thank you so much. It's not a question, it's just actually a comment. I just want to thank our speaker, because I might not be able to talk going forward. I'm on lunch right now. I just want to thank him for clarifying a lot of things today. I'm glad I attended. You know, I think the last two meetings, I mentioned something that I don't even think we as Nigerians, we were informed enough. You know, I don't think, you know, you can blame INEC. INEC wasn't prepared. But I don't even think Nigerians were well prepared and informed enough for the election. And I think this is really an eye-opening, you know, for us to make sure we familiarize ourselves with the Electoral Act, you know, read it, understand it, leverage people that can interpret it, you know, for us to make informed decisions, you know, because some of these things now we're getting to know, okay, the issue of FCT, the issue of compliance, and so many things, you know. There's a law and there's an interpretation of law, you know. For an expert like him to come in now and explain this, you know, it's really eye-opening. And I wish a lot of people can listen to this, like listen and attend this webinar. And I really just want to thank him enough for taking the time to come on here to explain that. That's all. Thank you so much.
You're welcome.
So much, Senator. I absolutely share those feelings. It's been a very fantastic one. Really very broken down, and some of them are very hard facts, that I know some of our people might not be very happy to have heard. But we don't do esotericism in PLIDE. We do facts based on the law and the realities on ground. So I want to thank you for that. Now let's go to the CBN and this Naira swap, which many people have described as Naira confiscation. I was listening to a senior lawyer talk about this a few days ago, and the person was arguing that basically, I think everything that the CBN does, that, well, the court can actually have jurisdiction over that. And the last time we had a webinar, I asked the question here: are we now stepping into territories that maybe we're going to regret at the end of the day? So the first thing, the Supreme Court did rule that the president does not have the powers in law. Of course, you have that, so I won't go into much detail so that you can educate us on that. Does not have the powers to have approved the redesign of the currency without recourse to the Federal Executive Council, as well as the Council of States. What does the law actually say? Number one. Number two, is there anywhere in the law, and this is not me, I'm asking because these are the questions going on. I think I have a little bit of economic sense to know one or two things, maybe not everything. Now, what people have said, the confiscation, that this is actually confiscation and not a swap, and that in itself breaks the law, that, what, the bank, the CBN does not have the right to determine the amount of currency in circulation. Even if they had that right, they cannot just adopt any policy whatsoever to have gone about it. Don't forget that the last time we had this, the Naira, the change in Naira policy, I mean, prior to that, Professor Chukwuma Soludo, current governor of Anambra State, actually just redesigned, changed it from paper to polymer, but it was exactly the same notes. The 20 Naira, he just moved it over to polymer, so that wasn't exactly a redesign per se. The last time we had it was when President Muhammadu Buhari was head of state between 83 and 85, General Muhammadu Buhari. So he's done the same thing again. So the ruling has gone in that regard. Now, also, question 3, where does this stop? If tomorrow, for example, the CBN grants Barrister Tope Adebayo a banking license, I can go to court and say, you know what, I will challenge it. But as far as I'm concerned, I feel Nigeria has enough banks. Why must we register more? Or if Barrister Tope Adebayo applies for a banking license tomorrow and the CBN says no, I might go to court and say, you know what, they have no right to say no, even when they follow their guidelines, saying, well, the law of the land, there is no way, it's got freedom of association, freedom of this, freedom of that, and if they're registered by the Corporate Affairs Commission, then they must be licensed as a bank. So where does it stop? And maybe when next they want to change the monetary, the foreign exchange regime, the mechanism, someone can also go to court. So are we not really treading on very, dangerous grounds? Even though people have celebrated the governors that went to court and all things, and some people also lambasted them. Where are we regarding this? Where does original jurisdiction lie? Does the Supreme Court have? I know you go to the temple of justice. You might not want to maybe condemn their lordships if they are wrong or something, but I trust you to say it as it is. So all those questions, and of course, any more information you can give us in that regard, because this is an ongoing policy that people are crying out on the streets. Where are we? What is the legality? Can you help us unpack? Okay,
let me just take the questions one after the other. It may not be in the order. I may not answer the question in the order you ask them, but I will attempt to answer the question. First and foremost, you need to know that the litigant before the Supreme Court were the states, few of the states of the Federation against the Attorney General, against the Federation of Nigeria. And so Kaduna State and 2 other states initially went to court. And the way their relief was couched quickly alerted, it alerted the Attorney General to raise objection to the jurisdiction of the Supreme Court to entertain the matter. In law, there's a doctrine called the doctrine of election. The doctrine of election allows you to choose your course of action. So when the state saw that their course of action was going to be declined by the Supreme Court because they were alleging direct infraction by the CBN, and the Supreme Court does not have original jurisdiction over the CBN. Therefore, they went back to amend their pleadings to now allege infraction of the Constitution by the President. The President is the President of the Federation. So he is acting as the agent of the Federation. And when there is a dispute between the states and the Federation, are you following me? That dispute can be resolved by the Supreme Court in its original jurisdiction. What is the Federation? The Federation consists of the 36 states of the Federation and all the local government. So by the past decision of the Supreme Court, when there is a dispute between the state, all the states together, and the Federation, that dispute will be brought to the Supreme Court. Now, Supreme Court refused some of the cases brought by the states in the past on the ground that the issues involved did not affect the entire Federation. Are you following me? But this case affects everybody in Nigeria. There's nobody that is not affected by this policy. And the policy was done in line with the directive of the President, who is the #1 agent of the Federation. So the case was properly instituted by the state, and the Supreme Court was right to intervene in the matter because we were already drifting to lawlessness. And I'll tell you what I mean. The Money Laundering Act limits the cash transactions that individuals and corporate organizations can undertake in Nigeria. Now, what do I mean by cash transaction? You want to buy land as a corporate organization. The Money Laundering Act says if the consideration, the price of the land is more than 5 million, you cannot buy that land in cash. And then if you are buying it in your personal name and the price is, I think, more than 500,000, you can't buy it in cash. There is no law that limits the amount of money that you can collect in cash as individual from your account. The only thing that is limited is the amount of transaction you can do in cash. So if I have 100 million, I can keep my 100 million inside my house. There is no law that mandates me to take it to the bank. It's my prerogative, it's my choice. We are not in a military era. We are in a constitutional democracy. If the government has been so lax enough to allow people to amass so much wealth and keep it at home, we should address that lapses, not limiting the freedom of people. Even if the government had intended to limit our freedom to hold cash, go through the National Assembly, get our law changed, limit the cash anybody can hold. Don't talk about transactions alone. So what they did was, like, I've read the judgment, the Supreme Court declared what Buhari and his team did as illegal, totally illegal. And that is the law as of today, because what Supreme Court says is the law. Now, why? Supreme Court is seen as infallible because they are final. But they have said, they have also warned that they are not infallible. He said they are final because they are infallible because they are final, but they are not infallible because they are not infallible because they are final. So, in view of that, that is the law as of today. The question is, does Supreme Court have jurisdiction over CBN? The answer is no. So if you have any ground against CBN as a private individual, you can't take it to Supreme Court. You can only go to Federal High Court to go and challenge whatever you consider to be either Federal High Court or State High Court, depending on the issue you have against them. You can only take it to either of those two states to go and initiate your proceedings. But states have taken the president to the Supreme Court through the Attorney General, and they have won. And that, for me, remains the law as of today. Thank you.
Thank you so much. Thank you so much, Barrister Tope Adebayo. I'm so happy that you've broken this down, and because that issue of original jurisdiction is very important. The jurisdiction over the central bank in the discharge of its duties. You know, so we've got just about 10 minutes more, and I'm gonna leave it for comments, questions, or anything, so that we can finish on time. I am hoping that we'll be able to bring Barrister back next week, and then we get back into our normal schedule in 2 weeks. We've got quite a few people lined up that we're hoping the elections would have been done and dusted yesterday, so we were to kickstart that process today, but the elections will not be concluded until next weekend. And so there's really no point even going into talking about the results and the fallouts from next week, since they will not be declared by Sunday night next week. A lot of them will still not be declared anyway. So questions, anybody has questions or comments, please raise up your hand. Does anybody have any comments or questions or contributions? Anybody? Okay, I will assume if there is no one, then that gives me room to be able to ask a few quick questions. Anybody? Okay. Now, basically, I'm just going to ask you this very controversial question. I know you might not want to comment on it, but people have asked this question and people have interpreted it in many ways, and it's caused quite a lot of chaos, the current chaos that obtains. People have said the forfeiture that Asiwaju Bola Ahmed Tinubu was alleged, well, should we use the word alleged because the document has been in circulation for a while in the United States many years back, that it does amount to confirmation of criminal activity, and some have alleged that it actually that forfeiture actually equates to being convicted. And I'm sure you have seen this. Please, can you help us break this down as well? And of course, this also applies to Atiku as well, with the case that relates to the former congressman in the United States and his former wife now, Jennifer Atiku, Jennifer Abubakar. And also, so would in each of these cases, especially both of them are forfeitures, but the one of Tinubu has been well documented. Does that actually, under the law, from what you've read, from what you've seen, is that confirmation of criminal activity? And does that, because our law says if you have been convicted of a crime, and for Obasanjo to have contested the 1999 elections, they had to be pardoned by the military authorities through the then head of state, General Salami Abubakar, because of the coup plots, whether right or wrong conviction. So in the case of Ashwabi Tinubu and Atiku in particular, would this amount to anything? And of course, maybe someone will be angry that why do I not include Peter Obi? And so I will include Peter Obi that there were but in his own case is slightly different because there were allegations of tax evasion with the Pandora Papers. You know, even though some do argue it's just being tax smart, but people have said tax evasion. And of course, it is a fact that it did put government money in a business that his family had a financial interest in. His family remain shareholders of that business. So looking at these three major personalities as far as these current elections go, what do you have to say to each of these allegations or cases documented against each other?
Well, first and foremost, let me start from Atiku. I do not have any record, or I've not read anything that shows that Atiku as a person was ever convicted of crime, either in the US or in Nigeria. And his wife is not Atiku. Assuming his wife was even indicted, you know, and an indictment is not conviction, you know. So I don't have any record that he was ever convicted or indicted himself personally. You know, what people don't know with respect to Ashwaju's case is that there's a difference between a criminal forfeiture and civil forfeiture. You know, forfeiture is one of my, you know, recovery is one of my very key area. And one thing I've always recommended to people is to government is to think of how to develop a robust legal and regulatory environment for civil forfeiture in Nigeria to enable Nigeria claw back a lot of stolen assets in this nation. So in the case of Tinubu, I think what they have is civil forfeiture. You know, somebody simply saying, you know what, I don't know about that thing. I don't admit any guilt. I don't admit any liability, but I'm willing to let it go. That will never, it won't stand, it will not prevent you from, that record is not sufficient under our constitution to stop him from contesting election. It's not a disqualification, you know, record. The third one is that of Peter Obi, talking about what he did by using investing in his family, state money in his family business. That is a matter for code of conduct. It should have been reported to the Code of Conduct Bureau, and the Code of Conduct Bureau should have investigated it. And if they find out that that constitutes an infraction of Code of Conduct, it should have been charged with the Code of Conduct. You know, Nigeria have laws. We have laws. We have institutions, but we just pay lip service to them. It's unfortunate. We just pay lip service to them. People have been talking about this Peter Obi thing since. Is it that lawyers in Anambra don't know what to do? The problem is those that our governors want to do worse, so nobody will take it up, because most of them are doing things that, you know, they do what make their personal interest conflict with their official position, and that's a breach of code of conduct. So all of them do it, so nobody is willing to challenge anybody, and so we go away with a lot of things. Today, Nigeria don't lack laws. We have laws, we have regulations, but enforcement and political will to enforce have always been our problems. Thank you.
Barrister, thank you so much. Thank you so much. I like that we have laws, you know, enforcement, and of course, when it comes to equity, must come with clean hands, and you know, people who are supposed to hold others accountable are like, you know, when I become governor, I might even want to do the same thing, and then because of that, they don't apply the laws. I thank you for that. Does anybody have any quick question or comments before I call on our director of budget to give the vote of thanks, and we close the session for tonight? Does anybody have any question or comments? It's been very, very rich. really, really rich tonight. Okay, I guess there's nobody. It's been a very fantastic time. And I love the fact that there have not been too many questions, because the way you've broken them down, they've been so clear. These are issues that people have been talking about all over the place, and particularly the issue, the law, the allegations against Tinubu, against Peter Obi regarding their financial dealings and all this. The way you've broken it down as well, it's just to say that effectively before the law today, that none of them has anything that can be against them. Thank you so much, Barrister. Director of Budget, please, in our usual style, can you please give the vote of thanks so we end the session? By that,
yeah, good evening once again. It's been an interesting evening. Barrister Tope Adebayo, on behalf of all of us, I want to say thank you for your time and sharing out of your immense knowledge and understanding of key issues with us tonight. It's been an interesting session. I thought, like the convener said, I thought it's something I will have to ask questions, but you've been able to bring things to very base level for everyone to understand, and this is well appreciated. Good enough. You have convinced and not confused us tonight, and we appreciate you for that, because that has enabled us to achieve so much within the time that we have. So, on behalf of the convener and the executive of PLIDE and every member, we want to say thank you for your time, for your contribution, and finding it suitable to be with us tonight. We appreciate it, and we pray God bless and continue to enrich you. Thank you.
I know you raised up your